Thank you so much to those who are joining us. We will give folks another minute or two to arrive, um, and uh, and then get started.
By the way, I'm going to be in Madison this coming weekend.
Oh, that's excellent.
We should follow up after this.
Okay, so I think that the folks entering from the waiting room are starting to slow down, so we will go ahead and get started. Um, Depending on where you're joining us from, good morning, good afternoon, good evening, or good very late evening. Thank you so much for joining today's webinar on In Pursuit of Justice, Arnon Nampa, Article 112, and Human Rights in Thailand. My name is Tyrell Haberkorn, and I'm a faculty member in Southeast Asian Studies at the University of Wisconsin-Madison. This webinar is being sponsored by the Justice in Southeast Asia Lab, or the JC Lab, generously funded by the Henry Luce Foundation, and the Article 112 Project, generously funded by the Anonymous Fund at UW-Madison. Fostered in 2021, the JC Lab fosters intensive exchange among faculty, graduate students, and practitioners, and public-facing events that aim to foster significant collaboration among these people. The JC Lab reflects the recognition that a growing number of MAs and PhDs in Southeast Asian studies are choosing to pursue professional careers outside the university, but more importantly, that there is a need for academic work and universities to be directly responsive to ongoing social justice crises in the region. Founded in 2023, the Article 112 Project is concerned with its namesake, Article 112 of the Thai Criminal Code, which defines the crime and stipulates the punishment for lèse majesty. Whoever defames, insults, or threatens the king, queen, heir apparent, or regent shall be punished with imprisonment of 3 to 15 years. Thailand has been a constitutional monarchy since June 1932, but the relationship of the monarchy to democracy has remained unclear, not least evidenced by the existence and use of this law. Over the past 20 years, the use and abuse of the law to suppress peaceful expression and silence discussion of crucial social and political questions in the Thai polity has risen at an alarming rate, with sentences reaching many decades. Despite the urgency of this rise and the analytic questions it necessarily raises, scholarship has remained relatively spare, and restriction of freedom of expression in Thailand remains unknown outside the country. The Article 112 Project responds to this by expanding scholarship and public engagement through undergraduate and graduate teaching, translation of key documents, and collaboration, such as the one today, with relevant US, Thai, and international scholars and non-governmental organizations. So to turn to today's event, many of you will be aware that the use of Article 112 to criminalize peaceful dissent has been on the rise since the 2006 coup, and that the number of cases has increased tremendously since the youth-led democracy movement in late 2020, with Thai Lawyers for Human Rights reporting that there are at least 278 people being prosecuted in 311 cases. One of those is Arnon Nampa, a lawyer, human rights defender, poet, and father. On the 3rd of August 2020, dressed as Harry Potter as part of a protest for the then emerging democracy movement, Arnon opened the door to questioning the place of the monarchy in equality. To do so was daring, given both Article 112 and the range of both unofficial and extrajudicial sanctions that people face for doing so. But it was essential. In his speech that day, Arnon said, quote, "Out of honor and respect for myself, and to honor and respect the brothers and sisters who have come to listen, and with the greatest honor and respect for the monarchy, it is of the utmost necessity that we speak about how the monarchy is involved in Thai politics today. We have shoved this problem under the carpet for many years, brothers and sisters. There is no mention of the actual problem, which means that the solutions miss the mark," unquote. Arnon knew that this was dangerous, and he also said, quote, This kind of discussion is not the toppling of the monarchy, but it is talking about it so that the monarchy will exist in Thai society in a manner that is correct and legitimate for a democracy with the king as head of state, unquote. Yet the prosecutors and judges refuse to hear this explanation and have interpreted his speech and that of many others prosecuted for violation of Article 112 as criminal. The space for peaceful discussion of the place of the monarchy in the polity, never a wide space, has narrowed even further. Arnon himself is being prosecuted in 14 Article 112 cases. 6 of these have been decided, and 8 are still in process. His current sentence for peaceful speech and dissent is 18 years, 10 months, and 20 days. He has been behind bars since the 26th of September, 2023, close to 18 months ago. Like other defendants in Article 112 cases, he has been denied bail repeatedly, despite the fact that none of his cases are final. Since being imprisoned, Arnon has written letters every few days to his 2 children, Fran and Gan, who are 8 and 2, and the letters are then shared widely. He's making a diary of his life and their life as a family. In his letters, he writes about the community of political prisoners inside. They drink coffee and discuss politics and ideas every morning. He writes about continuing to practice law and defend clients. He does so wearing his prisoner uniform underneath his lawyer's robe and with his feet shackled. He's writing to his children, but also to those of us who are outside. He's writing towards a democratic community, something increasingly in short supply, not only in Thailand, but around the world, including the US context in which I am currently sitting, and that he hopes that he and we will inhabit in the future. The Article 112 project has been translating these letters and publishing them as free open access PDFs. And in January, we published all of the letters, 139, from his first year behind bars. And you can easily find that if you just Google Arnon Nampa letters, you'll be able to find the link easily. Let me share a passage from his letter of the 20th of September, 2024. So he's writing about the solidarity of people working for the freedom of political prisoners. And he writes that, quote, "This is important. This is especially important in collectively changing the world. This is because everywhere in the world, authoritarian power or other unjust power operates to keep society down. This power protects the old society by not allowing the new society to be born. Those who have awakened from the illusion of the old society may not be able to bear it when they see injustice. Such illusions may take the form of nationalism or religion, skin color, or even gender identity, which are used by the old society to create divisions for humans to harm their fellows." So I share that just to give folks a sense of the work and the envisioning that he is doing in his letters. So today, our 3 speakers will talk about Arnon and the broad history of cause lawyers of which he is a part, the growing number of political prisoners in Thailand, and the advocacy for their rights currently being undertaken. Each of the speakers will speak for approximately 15 to 20 minutes, and then we'll have time for discussion. Just a note on process, we'll use the Q&A box for questions, so please put your questions there rather than in the chat or rather than sending them to me via email. If you have a question, just put it in the Q&A box. So let me begin by handing the screen to Frank Munger, Emeritus Professor of Law at New York Law School. Frank, the screen is yours.
Thanks so much, Tyrell, and thanks to everyone who's tuned in at whatever point on the globe you find yourselves in, or whatever time of day. It's morning in New York, not too early, so I hope the rest of you are quite comfortable wherever you are. So I must say that to an observer in New York, where I am, Arnon's imprisonment is shocking, of course. His arrest and punishment, of course, are at odds with well-established ideas about democracy and free speech. And punishment for lèse-majesté, speaking ill of the king, belongs to a bygone age. The idea that someone can be imprisoned for doing nothing more than suggesting the monarchy's role could be modernized seems almost laughable. But of course, the length of Arnon's sentence is no laughing matter. And it suggests the depth of a destabilizing contradiction in Thailand's political culture. Many scholars write about the preservation of Thailand's historically royalist elite political structure. But there's a growing body of research examining the origins of alternative interpretations of rights, and my own research belongs to that community of scholarship. My research explores the evolution of a community of dissenting lawyers and their efforts to create and defend alternative, liberating interpretations of rights. Excuse me. I try to defend the idea that their work has profound implications about who should rule and how, and may even be viewed as being increasingly important. If citizens are to have rights, and those rights can become active and meaningful only when they are put to use, lawyers then play an important role. They're specialists in doing exactly that, putting rights to use. So my focus has been on the lawyers. My research began in the early 2000s. Excuse me, I have a frog in my throat. Hopefully it'll clear up in a second. I began interviewing lawyers just after the adoption of the 1997 Constitution. That so-called People's Constitution might also be called a lawyer's constitution, because, as you know, the Constitution established rules creating a political structure, a number of independent institutions which could be used to enforce those rules creating powers of government and their limits, and rules creating citizens' rights. The Constitution also created independent agencies to make sure that politicians, bureaucrats, even police followed the law, and especially constitutional law. But what did the new rules actually mean? How did the new Constitution connect to Thai history, the intentions of the movement for constitutional reform? Powerful lawyers were involved in drafting the text of the 1997 Constitution and carefully preserving a role for the king, which we have discovered. But how could a small group of people's lawyers make a difference by interpreting law, both constitutional and statutory law, for the benefit of political outsiders, the politically weak, the socially marginal, social movements ignored by politicians, needy groups poorly served by bureaucrats or abused by the police or military? The story of this group stretches back to the middle of the 20th century and perhaps before, when the first lawyers for people's rights can be identified. They were few in number. Some made a living in part by earning money from businesses and occasionally by representing unpopular organizations like labor unions or communists, but no one represented the poor and others that were too timid to speak up. My interviews with more than 150 lawyers and nearly 200 others, I haven't done an actual count lately, who worked with them, organizers, law professors, judges, and NGO staff, foreign funders, and government officers, suggest that we can think of the legacy passed down to young lawyers like Arnon as coming from 4 distinct generations. Major changes in Thailand's political structure, social development, and international position created different contexts for their efforts, which led to different styles of practice and the creation of different legacies for the current generation, all of which are important. The 4th and perhaps the 5th generation are in the making now. Arnon is a member of the 4th generation. I'll just say briefly, I'm not going to go through this entire history, but the first lawyers that I was able to identify as advocates for rights were mavericks, really. That is, they were outspoken risk takers with an independent spirit. They didn't work together. They worked individually, perhaps with 1 or 2 others in a small firm. And when they succeeded, frankly, they were lucky. And they often didn't. And they often paid a price for that. A second generation was formed during the October uprising in 1973. Now, first generation lawyers the few who survived and continued to practice, some of them became quite well-known public figures, and they were mentors, teachers for the October generation. The October generation was a part of a social, of course, as you know, a large social movement. And what they gave to later generations was a social vision and of a law motivated by popular aspirations for greater participation in politics and a few more rights to speak out, to shape society, and to have their say in many different ways. The October generation, of course, was shut down, at least as a social movement, by the bloody massacre in 1976, which created doubts and second thoughts about how to bring about change and what it would achieve. But the ideal of popular democracy did not disappear. So at the close of this era, after 1976, we have two generations. An older generation of experienced litigators who'd survived battles by the skin of their teeth, some of them, but who would become icons of dedication to human rights, and a group from the second generation who were networked, shared a set of ideals which have motivated subsequent generations of lawyers. That's their legacy. A third generation, which emerged after 1980 under semi-democracy, has become extremely important for lawyers like Arnon. This group were inspired in part by memories of the October generation, kept alive in law schools and a small number of NGOs founded by members of the October generation. But they learned to defend rights under radically different conditions from those earlier generations. Space for political expression then, as now, was limited, but they could work for policy-oriented NGOs with foreign funding, or in small law firms that advised and represented social movements, criminal defendants, women, labor, slum dwellers, communities resisting destructive development. They were tutored by experienced practitioners who survived from generations 1 and 2. Many learned to work with grassroots leaders and trained organizers, which gave them special skills and created networks of mutual support. Above all, they formed a lasting network of activists across these areas of specialized practice. All these forms of legal practice were new, but they were also politically acceptable under semi-democracy because, in a sense, they were apolitical. They were focused on legal gains, wins in court, wins in working with policy. Increasing involvement of lawyers with social movements and social advocacy changed the nature of legal practice and at the same time contributed to the growing movement for constitutional reform. Now, Arnon is a member of a fourth generation. His generation entered the legal profession as he did after 1997, the great constitutional moment. This generation has distinctive features, some of which are legacies from the three previous generations. The fourth generation benefits from what is now, I think, an irreversible political commitment to courts and constitutional enforcement. Although you may feel quite skeptical about that, I think it is actually a thing, at least in principle. And that has the effect of allowing somewhat less space for arbitrary use of power and somewhat more space for dissent, although those spaces are places of ongoing conflict and kept open only because this generation of lawyers has new resources, among them international legitimacy and money, and not least a social media-based society, which is an incredibly powerful asset. That brings me to Arnon Nampa himself. For some of us, he is a hero. To the government, he's a public enemy. That identity grows from his success as well as his notoriety. And it has benefited from both the unique conditions of his generation and his own personality, but also the legacies of prior generations for rights. His legal practice shares Generation 4 characteristics. First, Arnon lives in a political social context that is quite different from earlier generations. As I said, the 1997 Constitution, and I think its successors too, promise more, and occupy a position of greater importance for good or ill in popular perceptions of government. New courts with varying degrees of independence from politics and numerous agencies with separate mandates for oversight make government administration more complex and potentially, at least, more responsive. Second, Thai society has been permeated by global media, information, and ideas. As a result, Thai civil society has more knowledge of itself and the world outside through TV, radio, and especially social media. Social media creates avenues for information expression and collective consensus building. Third, as a lawyer, Arnon is a member of a distinctive, self-sustaining professional community of practice. Lawyers with cumulative experience who learn from each other about how to practice law for similar clients and whose interpretations of law and methods of legal practice and professional identities differ from the mainstream legal profession. Consider how Arnon benefits from all this. In his legal practice, he's from a background which, in fact, quite a number of these lawyers for alternative forms of law share, from the Northeast. We know that the northeast of Thailand has a distinctive history which separates it somewhat from central Thailand. His career, like many of his contemporaries, is one of upward mobility, from a family that lacked education to a position of someone who has a university degree and a great deal of knowledge about the world. He chose to study law in part because he admired a grandfather who stood up to a village headman, stood up for justice and the voices of his friends. Arnon admired that, but also he became a lawyer because he's Arnon. And his friends said, "You'd be a good lawyer. You're tough. You speak out. You stand up for justice." So that's where Arnon went. And from the beginning, he wanted to be a lawyer. At Thammasat and Ramkhamhaeng universities, he learned his first lessons in activism from student clubs and from activities outside the classroom, which kept alive the October generation's ideals. He says he learned more outside the classroom than in it. After graduation, and here's where the community of practice kicks in, he followed law school friends to a law practice established by lawyer Surachai Trongnam, a third-generation lawyer known for litigation skills and defending environmental causes, among many other kinds of causes. Surachai helped create what I think is the first independent public interest law firm, and from there established Thailand's premier environmental litigation practice and law. Surachai's success created a financial base for training young lawyers who might otherwise have had to seek training in conventional law practice. Surachai's practice benefits from the independence he achieves from foreign funding, but also from its focus on building professional expertise, which is admired by both academics and government officials alike. Known for his skill in litigation, Surachai carefully keeps his well-known political sympathies separate from his legal practice. And I have to note that this separation of legal from political is something that began in the third generation, and it is in fact a characteristic that's carried over to the fourth generation, at least on the surface of things. Arnon, of course, stepped across that line, and I'll talk about it in a minute. It is the continuing basis for the legitimacy and political acceptance of this community. And it's a very fraught line. Until 2010, Arnon was careful to embrace the apolitical identity of a legal professional. As he said frequently, his practice to that point had no color. He represented all sides, all people in need of defense of their rights. From this community of practice, Arnon learned important lessons about how to be a lawyer. As a lawyer fighting to expand and establish new rights, he says he was taught to think outside the box. That's not something lawyers are taught in a Thai law school. And he was taught to seek justice beyond the law. That's the phrase that he used. He meant that the words in a statute or a constitutional provision must be interpreted and understood in context to understand their full meaning. Law must be translated for use in real life. Justice means achieving what the law promised. Interpretation in context, using intuition, experience, and shared values is radically different from the narrow conservative interpretation of textual language conventionally taught to lawyers in Thailand and employed by Thai judges, and which conceals the unexamined presumptions and ignores the consequences of court decisions. The tradition of justice beyond the narrow text of law reaches all the way back to the efforts of the October generation. Finally, Arnon benefited from the collaboration within a community of trusted and like-minded colleagues who differ from the mainstream in their commitment to defending rights of ordinary Thai and seeking greater protections for rights, and he's worked seamlessly on many different social causes with many lawyers. Now I come to my last point. Practical knowledge and professional skill are one thing, but a professional identity is something more. The ideals and purposes which Arnon embraces grow from the aspirations of earlier generations of lawyers, but he's adapted them to his own vision of justice and his own circumstances. In one of his first letters from prison, Arnon asks his children to imagine him in his lawyer's robes. Robes are a symbol of the lawyer's commitment to impartial justice. In Arnon's words, a legal practice has no political color, but unspoken, robes are also a symbol of the lawyer's power and distinguish the lawyer from the ordinary citizen before the court. Courts are all about power, power which Arnon may at times deploy. But ironically, in recognition of that symbolic importance and of his clothing, Arnon is stripped of his robes when he's brought before the court to defend himself, and instead he's forced to wear prison clothing and chains. The contrast is deliberate. And Tyrell, you said that he wears that clothing and the chains under his robes. Is that right? I didn't know that. He doesn't mention the letters. Well, that really is worth digging into and thinking about, isn't it? But the robes change him. He hopes that his children will read the letters, and indeed, much of the text of the letters is addressed directly to the children and his hopes for them. And he wants them never to think of his robes as a mere costume. He hopes they'll eventually understand his robes are who he is and what he stands for when he acts as a lawyer. Until 2010, Arnon defended victims of political abuse or economic oppression, regardless of politics. But in 2010, he changed direction after violent suppression of red shirt demonstrations in Bangkok and government persecution of political dissenters, including a rapidly rising number of persons accused of lèse-majesté, as Tyrell has mentioned. The 2014 coup added fuel to a new identity. He made a decision to defend the victims of a repressive state and to take up their cause specifically. He helped form Thailand Lawyers for Human Rights, which has maintained high standards of professionalism but has a partisan identity by defending the government's most severe critics. We should appreciate that the survival of Thailand Lawyers for Human Rights as a source of legal dissent suggests that the rule of law has taken hold in a way that has not existed before. There's a great deal of evidence to the contrary, too, but also some seeds of change, and Arnon's generation is forging a path that's different and more advanced than that of generations that preceded it. But Arnon's identity as an advocate has evolved further. Perhaps the elitism of the robe, inherited from British practitioners in the Inns of Court, creates too much distance from the social cause in which he believes. I recall a saying I heard among labor lawyers of my generation who fought long battles for union recognition. You win in the courts when you win in the streets. Arnon removed his robes to take to the streets. Arnon's professional identity blends the lawyer and the social revolutionary. He's often won battles as the former, but has only faced defeat as the revolutionary, at least in court. The battle in the streets is still undecided. Only time will tell whether the next generation of lawyers will win victories for rights their clients are now denied. But victory is unlikely until Arnon and political fellow travelers can win the battles for the streets that led to his imprisonment. Thank you.
Thank you so much for that really powerful account of Arnon's life in the broader history of those who are fighting to use the law to create justice in its many possible forms in Thailand. let me now hand the screen to Akanit Tadi from Freedom Bridge.
Hi.
Hello.
Hello, everyone. This is Nit from Freedom Bridge. I have a bit of a slide, so I would like to share my slide. Um, um, Sorry, it's loading. So I will also put it in the group chat, just in case it's easier for other people to look at the slide from here. So yeah, good morning or good evening, everyone. My name is Nit. I am a program manager at Freedom Bridge. We work to support political prisoners in Thailand. Freedom Bridge started from the work of Thai lawyer human rights together with Arnon's family. In the beginning, they provide support to Arnon and a few activists who were in prison, delivering food and aid. But then the amount of people going into prison keep growing. So in May 2024, we started an organization, a new project called Freedom Bridge, which deliver psychosocial support to political prisoners and their families. So as you know, Thailand have had a long history of having political prisoners, including political prisoners related to lèse majesté law. But then in 2020, there was a big rise of protests led by young people and students, and that led to charges of a lot more people. And recently, there are famous cases that you might have heard of, such as Bung Netipon, who died in detention, Arnon Nampa, or Anchan, who have been sentenced to more than 50 years at the age of 63. So the definition of political prisoners that we work with is that political prisoners are individuals who are detained due to their political belief and actions. We do not differentiate the support that we provide based on the charges. So we basically help everybody who's been charged with you know, a political charge, or whether if there's a political treatment to their trial or their case. There were some cases that they have been arrested due to non-peaceful matters, such as there was some possession of fireworks that they take to the protests. In Thailand, this can be considered a non-peaceful matters, but during their trial, the process has been very political, and the way they're treated, the access to fair trial and rights to bail. So we also consider this group of people as political prisoners, and our help is mainly humanitarian assistance. And we also do advocacy, but we don't differentiate if they are activists or not. Imprisonment not only impact individuals, it also impact their family. The average age of political prisoners that we are working with now is 33 years old, and majority of them are men, which mean that they are in working age. They are in the age that they provide for their family. Being in prison mean they cannot provide for their family. They cannot perform the role that they have been doing. 13% of them are males, females. Majority of them are mothers, and then there are some LGBT plus. Thailand has the highest number of political prisoners under lèse majesté in the world. As of now, the highest record sentence is 54.6 years. 53% of our political prisoners are charged under lèse majesté law. Last year, one person died in detention. And since the protest in 2020, 1,959 people have been persecuted. We were founded in May 2024, so it's been around 10 months. We have supported 68 political prisoners. 30 of them were released in 2024. 45 of them are now currently still being detained. The average days of detention of people who are still in detention now is 607 days. So most people have already been in prison for more than a year and a half. Most of them are being denied bail. So our support cover food, cash deposit. We also help upon release, and we also support the families. This is in the case that the family have to face extreme hardship after their loved one or their breadwinner have been in prison. Our work have reached 21 prison across 11 provinces across Thailand. So you can be in prison anywhere, depending on where the charge have been filed. So there are some people who have been in prison in the Chiang Rai, which is the north of Thailand, or in the deep south in Narathiwat, even though they are not from there. The work that we provide at Freedom Bridge is divided into 3 different phases. In the beginning, this is before detention. We provide counseling. We prepare them to go inside, make sure that they know that there's support out there. We do family counseling, risk assessment, and all that. And then once they are in prison, we help to deliver food in prison that it is available. In some prison, you cannot order food. In some prison, you can. Things in Thailand is generally things are centralized. So if you're in the central, maybe there's more access to your rights. So we make sure that their rights are, being protected. Their nutritional needs are met. They receive essential items like soap, shower, cups, and all that. You need to buy all of that. There's also a lot of censored on communication for prisoners in general, but especially for political prisoners. So we work with the volunteers lawyer from Thai lawyer from human rights to visit and help that, making sure that they have access to communication. We do family support, educational support, and we support family members who are elders or people with disabilities. Many people were the sole provider of their family, which means that their children education is affected. So what we are trying to make sure is that their children still get to go to school, even though the provider is in prison. Upon release, we provide financial support upon release, because some people, they can be in prison for a long time. They lost their job. They don't even have a phone. Many people experience some challenges with their mental health after release. And then there's career training or job opportunities that we are trying to refer them to once they are out, to make sure that they can regain, ability to take care of themselves and being able to support themselves and others again. Interim advocacy, we also do some advocacy, but we a lot of the time is a partner with Thai Lawyer for Human Rights in terms of like input for discrimination of human and growth, inputs on rights to health. Or last year there was an event in Washington DC called Set Them Free, which was about political prisoners from many different countries. So we were there to talk about political prisoners situation in Thailand. Half of our budget come from local support in Thailand, donation from average citizen. The donation that we receive is less than majority of our donation are less than 1,000 baht, which mean it's less than $25, less than $20. So still a lot of grassroots support. In the past year, we have been able to provide support because we receive this grassroots support from people in Thailand. So yeah, so you can see that half of our budget last year came from overseas. And almost half of the donation, which goes into providing support for political prisoners, come from Thai people. Then this year, the estimate budget is around 200 US dollars, although we are affected by the funding cut that you all have heard about. So this year, we are trying to do more of fundraising of our own to make sure that we can sustain the support to political prisoners and their families. So 2025 goals of Freedom Bridge is to, continue providing support for political prisoners and their family, increase awareness of political prisoner situation in Thailand. We also have a project partner with FIDH, International Federation of Human Rights, on prison report and to do policy recommendation, because in Thailand, the prison system is different. Like each prison, there's no central standard. Each prison can be different. Depending on where you end up, your rights can be different. You can be treated differently. In some places, your family can visit you every day. In some places, you can only people can only visit you once a month. So what we are trying to advocate for is to also that there's a central standard that protects prisoners' rights in general, not just political prisoners. We are trying to do community engagement, and that includes working with partner organizations on many different issues, including the amnesty bill, which we are still waiting for, and hoping that it will come back up again. So one of the topic that we would like that if you are following Thai news, one of the thing that you could keep an eye on or show support is on the amnesty bill of Thailand. There's a prison report that we help doing the research that will come out at the end of this month or early April, and then we are trying to see what Thailand would do regarding home detention, because Thai prison is one of the most crowded prison in the world. There's policy that one Thaksin already benefited from, but other people have not benefited from yet, is home detention, which many of our clients should benefit from, since they are they have serious health issue or they are elders. The way that you can support Freedom Bridge is through donation, partnership. You can also volunteer with us. You can follow and stay connected with us on this channel. If you're in Thailand, you can donate directly through our bank account, which you can scan with your PromptPay here. But if you're in the States, there's an organization called Engage Thailand, which is trying to bring resources and engagement to Thailand and Thai political issues. If you're in the States, you can donate through your card and you can get tax deduction. So I have, it's in the presentation. If you're interested, you can go to the link and find out more later. So yeah, that's pretty much about the work of Freedom Bridge. We are currently supporting 45 people in detention. So if you have any question or if you are interested in our work, you can go to our website or reach out to us directly. Thank you.
Thank you so much, Nit. That was so powerful and inspiring and sobering. Especially, I think I had not thought about the tremendous geographic scale of 21 prisons in 11 provinces. and the difficulty that places on families. So let me hand the screen to our final speaker, Akarachai Chaimaneekarakate from Thai Lawyers for Human Rights.
Hi everyone, just give me a second. Let me just share my screen very quickly. Okay, I believe everyone can see this. Perfect. Let me just put it into the presentation mode. Perfect. So yeah, hi everyone. Thank you so much for joining us here, whatever it may be morning, afternoon, or evening, depending on where you are. But I'm very happy to be able to speak to you about this very important issue. So my name is Akarachai. I'm the advocacy lead at Thai Lawyers for Human Rights, and I think Kun Frank and Kun Nit have mentioned, Ajahn Tyrell has mentioned, we provide legal representation to people charged under the criminal laws for exercising their fundamental freedoms, criticizing the government, the military, or the monarchy. Now, a few things that I want to look at today. Just a bit of a background. As some of you may have heard, back in 2020, there was a mass youth-led pro-democracy movement. And when I say youth-led, I'm talking about really young people, high schoolers, middle schoolers, who took to the street to protest against what they believed to be a form of injustice. They demanded a few things, that the then Prime Minister Prayut Chan-o-cha, who orchestrated the 2014 coup, that he resigned from prime ministership. They asked the government to stop harassing people who took to the street to simply exercise their fundamental freedoms. And last but not least, they asked the government to amend the constitution, which was drafted and passed during the rule of the military junta. So those were the three demands we saw earlier on in 2020. Then came another big demand, which some of you have already mentioned, and some of you must have heard about in Thailand, and that's the demand for the reforms of the Thai monarchy. And I will get into that a bit as to why that has become a very controversial issue in Thailand and a central issue, arguably, in the 2020 pro-democracy movement. But after 2020, when a lot of young people took to the street, when they criticized the government, both offline and online, what we saw was the government cracking down on these individuals through repressive laws. Since July 2020, almost 2,000 people have already been charged under various laws. I'm talking lèse majesté, I'm talking sedition, I'm talking Computer Crimes Act, and so on and so forth. The emergency decree as well, enacted and enforced during the COVID years. And among those people, we have had more than 300 lèse majesté cases since it was used, since the government resumed its use in November 2020. So almost 300 people have been charged under this law for speaking about the monarchy, for peacefully demanding for monarchy reforms. But let's look at what this law actually is. So when I say lèse majesté law, when I say section 112 or article 112 of the Thai Criminal Code, the text is whoever defames, insults, or threatens. You can't do these three things. It defames, insults, or threatens. Against who? Against the four people: the king, the queen, the heir apparent, or the regent. And if you do these things, the punishment is 3 to 15 years of imprisonment. An interesting note is that 3 to 15 years of imprisonment is also the punishment for manslaughter under the Thai Criminal Code. Just a bit of a comparison there. But also something to note is that Section 112 is a national security offense. And because it is a national security offense, anyone in Thailand can file complaints against other people at a police station in order to kickstart official investigation. And that's why you see cases popping up across the country, in the north, in the south, in northeast, in the west. Because if you see something online you think is too critical of the monarchy, you can walk to your local police station to accuse the author of the post under the lèse majesté law, thereby kickstarting an official investigation, which would require the author of the post to come to your perhaps a city, hometown. Maybe if that person lives in Bangkok, it doesn't matter. He would have to make his way all the way to Chiang Rai to the north if you were to file complaint against him in the north. And that's one very problematic feature of the law. Now, I want to spend the rest of my time to talk about Arnon Nampa. I actually had many of these slides prepared, but I changed them last minute, actually a few just right before this presentation, because I was at the court today, the criminal court today, to attend one of the cases against Arnon Nampa. And it got very heated, and I will get into those details in a bit. But let's look at this photo together. That's an image of Arnon Nampa wearing in a Harry Potter themed protest. And that's because at the time in 2020, we needed to find a way to creatively speak about he who shall not be named. A quick summary of what the status of cases against Arnon Nampa. As Ajahn Tyrell mentioned, he's been charged with lèse majesté, prosecuted with lèse majesté in a total of 14 cases, 6 of which he has been found guilty, and there's still 8 cases remaining against him under the lèse majesté law. He's been sentenced to more than 18 years in prison already, and that sentence is likely to increase this year as more judgments in the 8 remaining cases slowly come in. He's been in prison for 527 days already since he was sentenced to imprisonment under the lèse majesté law in September 2023. But what did he actually do? What did he actually say to get all these punishments? Let's look at some of these cases together. The first case I want to look at is what in Thailand we call the Harry Potter 1 case, and that's because it was a Harry Potter themed protest. In that protest, he criticized he who shall not be named. And that's a big protest in Thailand's modern political history too, because arguably this was one of the first times that someone in Thailand spoke very openly, publicly about the king, about the monarchy in a very critical manner. And that very much, I think, either raised the ceiling, or if not almost shattered the ceiling on discussion about the monarchy in Thailand. He critiqued the Thai constitution and the provisions thereunder about on royal prerogatives, and he criticized the role of Thai king in Thai politics. For that, he was sentenced to 2 years in prison, more than 2 years in prison. Then, another case. 1 year after the Harry Potter 1 protest was the Harry Potter 2 protest. Again, he gave a speech in the public. He spoke about how all human beings should be equal regardless of their status. He talks about the management of the crown property. And one of the things he said, and I think this is quite interesting, because he said that in order to preserve the institution of the monarchy in Thailand, the crown property needs to be properly managed. That is to say, the crown property ought to belong to the institution of the monarchy and not the individual occupying the palace at the time. That is to say, not to the monarch. It should belong to the monarchy, not the monarch. But then in 2018, Thailand passed a law transferring assets, property that used to belong to the institution of the monarchy to the monarch. That is to say, into the king's private ownership, personal ownership. He said that in doing that, you are putting the institution of the monarchy in jeopardy. Because in the scenario of succession, in the event that we do have the next king, there's a risk that the next king would not have with him the property that used to belong to the institution of the monarchy. So interestingly, what Arnon was calling for could be said to be in favor of a more democratic, a more enduring form of monarchy in modern in democracy. He also criticized the government's COVID-19 vaccine procurement policy because at the time, there were questions about why Siam Bioscience, a company in Thailand, was awarded a contract to manufacture, produce, distribute AstraZeneca, Oxford COVID-19 vaccine. And it turned out that that company was exclusively owned, 100% shareholding by the Thai king. So again, for asking that question in a public speech, he was charged and convicted with lèse majesté. 2 years in prison for that. And in another case, on Facebook, he posted a letter to the king. He spoke about how the many conduct of the kings was not in line with democratic principles. He was talking about how the use of taxpayers' money allocated to the institution of the monarchy, many times it was unnecessary, especially when we are talking about this post being made in 2020, when the government had difficulty dealing with all the COVID cases. Many people were going through a lot of hardship because of the pandemic. Arnon basically asked, look, is there a better way to spend all this money amid the pandemic? Again, for that, the authorities did not like what he had to say. He talked about the need to amend the constitution, and he raised a very important question. That is to say, the 2017 constitution that Thailand has today, it was approved in a referendum in 2016, a year before its promulgation. But before it was promulgated, before it was enacted, it was actually changed by the government at the request of the king, despite the fact that people had already approved the draft in a referendum in 2016. So Arnon said that, look, that's not a democratic way to implement, to enact a constitution. How could one person request the government to amend the constitution when that draft constitution had already been approved by the people? Again, they did not like what Arnon had to say. And for that, that's 2 years in prison for him for making that speech, discussing all these matters. And another case that I want to talk about, again, another Facebook post case, a lot of online expression case. Arnon asked people on Facebook, how could people losing faith in the Thai monarchy, how could it be a crime? He also argued that Section 112, lèse majesté law, shouldn't be used to silence criticisms about the monarchy. And he really questioned whether people who disagree with him on the issue of monarchy reforms, whether they truly did not see any problems with the Thai monarchy, whether they really truly believe that it is an institution without any problems. Again, for that, he was sentenced to 4 years in prison. But I want to come back to this Harry Potter 1 case because what happened late last year was really interesting. Because there was a lot of fair trial rights issues in this case. So some of you may know, in a trial, usually how it unfolds is you question prosecution witnesses, and after questioning prosecution witnesses, you question the defense witnesses, and then you go to the verdict, long story short. In this case, while questioning a prosecution witness, it was the defense turn to question the prosecution witness. But Arnon argued that, look, because he was accused of lying in his speech about the Thai monarchy, he made a speech about how the Thai king frequently went to Germany. He spoke about how a lot of money was allocated by parliament to the institution of the monarchy, and the prosecution accused him of lying in these speeches. So he said, look, I didn't lie. I'm asking you, the court, to issue subpoena to help me get my hands on this evidence so that I can prove the truthfulness, veracity of my speech. And the court refused to do that. So Arnon said, look, if you're not gonna help me get my hands on this evidence, you are basically not allowing me to fight the case fully, that you're tying my hands as I'm fighting my case before the court. So Arnon said, look, I'm not gonna question the prosecution witness unless and until I have access to important evidence that can prove the factfulness, the truthfulness of my speech. And the court said, well, in that case, if you don't want to proceed, we can move to verdict right away. And that's what happened. The court decided to just cancel all the other witnesses on the list and just said, since you insisted on not questioning this prosecution witness, we can move directly to the verdict. Arnon therefore removed his shirt to protest the court. And removing one's shirt falls under this theme of Thai political prisoners, Thai political dissidents, feeling that perhaps their body is their last weapon of choice. They go to court, the judges won't give them what they want, help issue subpoena to help them get their hands on important evidence. They wouldn't be able to fully discuss about the monarchy in court. And many times they need to use their body. They go on hunger strike, they go on hunger strike, they remove their shirt as a way to protest injustices in court. And that's what Arnon did. And interestingly, because he did that, he was charged in another case. He was held in contempt of court for removing his shirt in the courtroom to protest the court's decision, refusing to give him access to important evidence to rebut the prosecution case, accusing him of lying. And in addition to him having been found guilty in the Harry Potter 1 case, right now there's a great risk that he's going to be found guilty for contempt of court for removing his shirt too. And that's the case I was in court for today. Immediately when I went into court earlier today, the court actually tried to kick everyone out of the courtroom, trying to impose a secret trial order, not wanting anyone to be in the courtroom as they try to question witnesses about what transpired on the day that Arnon removed his shirt in the courtroom. And they didn't, and so it was very problematic. And there's a lot of battles between the defense and the prosecution and the judge. And in fact, the judge refused to call one of the witnesses who was present in the courtroom on the day that Arnon removed his shirt, which means what happened today is that they questioned all the witnesses that were not actually present in the courtroom. The one witness that was in the courtroom on the day Arnon took off his shirt, the court refused to question that witness. And now, later this month, again, they will move directly to verdict, whether or not Arnon would be found guilty of contempt of court. So as you can see, there's a pattern there. If you refuse to participate in the proceeding, no matter how unjust you believe it to be, the court can easily move to verdict. And that's what will happen later this month. And the last thing I want to talk about is the reason that the court used to justify its decision not to issue subpoena to help the defense, to help Arnon get his hands on important evidence to prove the veracity of his speech. And that is Section 6 of the Thai Constitution. You can see the text of the Thai Constitution. Section 6 is the king shall be enthroned in a position of revered worship and shall not be violated, and that no person shall expose the king to any sort of accusation or action. So the court said, look, these evidence that Arnon is asking for, king's travel record to Germany, how much money the parliament allocated to the institution of the monarchy, the manner in which the institution of the monarchy spent those money, the court said, look, that may expose the king to some sort of accusation in in allowing you to have your hands on this evidence and make your case, you may end up violating the king. The king would no longer be in a position of revered worship if you were to be allowed to discuss these issues in courtroom. So the way they interpret this provision, this constitutional provision, as you can see, it's being used in a very broad way to justify the lèse majesté law, to justify the court's refusal to help the defense get their hands on important evidence that can prove their innocence. In fact, this is also the same argument that the court used to justify the constitutionality of Thailand's lèse majesté law. The court says, look, the king is obviously in a position of revered worship. According to the constitution, he should not be violated. So that's why we need the lèse majesté law to prevent people from violating the king by criticizing the king. If people can freely criticize him, then he will no longer be inviolable. He will no longer be in a position of revered worship. So in fact, the lèse majesté law is not only important to the institution of the monarchy, the court is saying it is constitutionally required. If you don't have the lèse majesté law, Section 6 of the Constitution cannot have practical effect. That's the line of reasoning we are seeing now from Thai court. The use of this constitutional provision to constitutionalize the lèse majesté law. And I think that's the last thing I want to say. And the last thing I want to say is that we think the next best step now is to call for people's amnesty. That is to say, there have been thousands of victims of political prosecution since going back all the way to the 2006 coup. We think people who exercise their fundamental freedoms since then should be granted amnesty. And we think that's the best way forward for Thailand. And I think Akanit mentioned this, especially for those in the States. Engage Thailand is a non-profit set up in the state. And if you wish to support the Thai pro-democracy movement, please feel free to visit this website, and please feel free as well to donate and contribute through Engage Thailand. And that's one way you can support Thai democracy. Thank you very much.
Thank you so much for your powerful and comprehensive account of what has been happening in the courts, especially today. I have so many questions that I would like to ask, but I actually first want to, as we're waiting for folks to add their questions to the Q&A, I wanted to offer to the three of you, if you sort of the right of first questions to one another, if there are things that you would like anyone else to expand on. Or
I think there are two questions in the Q&A already.
Yes. I was just waiting to see if there were a few more. I will actually just start, because a question that I have, Akarachai, is there is something quite profound about the fact that it is the courts have interpreted that to launch a coup is not a crime and is not destruction of the Constitution and is not unconstitutional, but that to peacefully question a key political institution, to simply question it peacefully, is both a crime and is in contravention to the Constitution. And I guess actually this is a question. It's a question for both you and Frank about what you think this means in terms of both a history of struggle over the meaning of law and of the Constitution, but also what it portends for the future, and actually for Akanit as well. What are the potential prospects of this, the potential impact of this on the possibility of the amnesty bill being passed, and what might be included in it?
Well, I have something very briefly to say about that. First of all, Akarachai, that was a fabulous presentation. I thought it was very helpful and placed everything in a really nice context. But this is for some time, I've thought that Thailand would benefit from a much more robust discussion by scholars and commentators from the public about the nature of the Constitution and about the jurisprudence being created by the Constitutional Court. I mean, that's something that would certainly generate a large literature in other countries with a Constitutional Court where freedom of speech wasn't suppressed and where academics and the press could indeed comment. Just the fact that the Constitutional Court felt it was necessary to carefully weave together its rulings, the constitutional interpretation, Article 12 in the way it did, which is, I have to give them some credit, it's very clever weaving together of those sources of authority, but it's certainly not the only way to put them together or the only way to interpret the history. Is there, I mean, you'll know this much better than I will, is there now a dialogue about this? Not on the stump, at mass protests, but I mean, in the scholarly literature or in the press about the strengths and weaknesses of the court's jurisprudence. This is a big change for Thailand to have all this stuff out in the open, in a sense, to have the opinions accessible to a larger public. That changes the nature of the game. So I'm wondering exactly how far that game has progressed.
I think I can take this one very quickly ครับ thank you ครับ อาจารย์ Frank yes the evolution of Thai jurisprudence on section 112 on the interpretation of this constitutional provision on the king's inviolability and sacredness of revered worship, that's relatively new and not new at the same time. It actually first started back in 2012 in a constitutional court ruling in another Thai political prisoner case, Kun Somyot. And that's the origin story of the court relying on Section 6 to justify the constitutionality of Thailand's lèse majesté law. Based on my understanding, a number of Thai scholars have written about this, but not a lot. And I think for many reasons, one of which is there's actually research on this issue carries great risk.
Yeah.
It's interesting to note that Thai courts have not been the only courts in the world that have interpreted similar provisions in other constitutions in other jurisdictions. For instance, in Spain, the Spanish monarch also is inviolable and sacred under the Spanish constitution. Same thing under the Belgian constitution, for instance. And the European Court of Human Rights has actually intervened in lèse majesté cases in Spain before, for instance, to make it clear that despite these wordings in the constitution, that does not mean that you would be allowed to use lèse majesté law to prosecute your people. That is to say, these constitutional provisions simply speak about the symbolic position of the king under the constitution. It in no way means that the king is immunized, shielded from all criticisms, especially in a democracy. So there have been alternative interpretations by the European Court of Human Rights that shows that what Thai courts have been doing with respect to this provision is definitely not the only way to interpret this provision.
Yeah. Okay, interesting.
Thank you both so much. Let's go to one of the questions from Jong-Woo Lee in South Korea, who notes that recently I am so worried about Kanun's hunger strike. I hope his mother could get some support from the program as well, since she might be under mental suffering for her son's situation. Do you have any plans or discussions on it in Freedom Bridge? And then another question is that are defendants' rights to defense properly ensured during the investigation process or in court when additional charges are brought against defendants? And so let me hand the floor to you first, Hunmi.
I guess I will take it first. So right now, Kanun, one of the activists who have been in prison for almost 1 year already, is on hunger strike. He's a master degree student. He was a paralegal, and he have been charged with lèse majesté. So he currently on strike, asking for his right to bail. And so yes, Freedom Bridge, we have a therapist starting with us on Monday. And on Tuesday, we met Kanun and his family in court. So yes, his mother is in great distress. So we are planning to work with her to see what we can do. This is actually the case for many political prisoners. Since the majority of them are around, age 33. And they go into prison, they meet other political prisoners. They tend to be, in the beginning it's hard, and then with a little bit of time, they tend to adjust. But the people who are in the most psychological distress are actually their loved ones outside. So that's why we are also trying to, provide mental health support for the family, because they are actually the one who are experiencing more pain of witnessing their loved ones going through this. So yeah, we have the plan to work with her, and we are following his Kanun's hunger strike closely.
Let me take on the question about fair trial rights. My quick answer is at both the investigative police stage and at the court stage, we have seen quite a lot of violations of fair trial rights. Just to give you an example, there are numerous cases of individuals being charged without their lawyers. Many times they would be brought up to the police station, and the police would either not allow the lawyers to meet the clients, or the police would proceed to interrogate the clients in the absence of the lawyers. And many times the clients or the individuals would simply be asked or invited to go to the police station just for the police to ask some questions, only for the police to find out that the police was planning to charge him with a crime, say lèse majesté. So at the investigative stage, we have seen quite a number of violations, access to lawyer being one of the main issues. Now, at the court stage, judicial stage, when things proceed to court, we have a lot more violations, unfortunately. And this concerns things that I already mentioned, fair trial rights. That is to say, a principle of equality of arms. When trying to fight a legal battle before the court, both the prosecution and the defense should have the same number of arms, weapons, in order to prove their case. But then in many cases, especially lèse majesté cases, the defense needs to fight with their hands tied behind their back. That is to say, they can't get their hands on important evidence that will prove their case. That's a violation of the principle of equality of arms. Or, for instance, when they question witnesses about the monarchy, since it is a lèse majesté case, and we would think that questions about the monarchy are bound to be asked in the courtroom in a lèse majesté case, when the defense lawyer tried to ask questions about the monarchy, many times judges would not note those questions down. Judges would say, look, we don't need to go there. Look, these are irrelevant questions. This doesn't have to do with the case. Despite the fact that the defendants were accused of criticizing the monarchy, yet questions about the monarchy was a king in Germany, about how much budget was allocated to the institution, sometimes wouldn't be allowed to be asked in the courtroom. And we had issues with impartiality of judges as well. And by impartiality, I mean lack of impartiality. We would have we have seen many cases where lawyers would already receive, or defendants would already receive prejudicial comments from judges when they first enter the courtroom before trial began. Judges would tell them things like, these are things you shouldn't have done, you should have known better, these are things you shouldn't do. So already assuming that the defendants did what he was accused of doing before trial began, and already assuming or presuming that what he or she did was inappropriate, shouldn't be allowed, inappropriate. So again, impartiality, another big issue as well. And I suppose most importantly and most problematically, independence of judges, or the lack of judicial independence. In many cases, when it comes to whether defendants should be released on bail, whether hearing should be postponed because one of the defendants is a university student who couldn't be in court on the day because she needed to take an exam, or whether the defendant needed to undergo chemotherapy because he had cancer, whether the hearing should be postponed, whether people should be released on bails, many times judges would need to leave the courtroom to go ask the court executive before they could come down and give a decision. And they would tell you, look, having consulted with the court executive, the hearing can be postponed. Having consulted with the court executive, you cannot be released on bail. So we question, how much power does the presiding judge actually have to make decisions about the cases over which he or she is presiding? Or in fact, there's actually a regulation issued and passed by the President of the Supreme Court, which requires judges in national security cases, of which less majestic cases are one, to send a draft order or judgment to the chief judge for them to be looked at, for them to be reviewed before they could hand down those orders or judgments. So again, when it comes to judicial independence, that's a huge issue. Yeah, so to answer your question, when it comes to the defendant's rights at both the police state, investigative stage, and the court stage, we see violation all along the way.
Thank you. Thank you so much. Another question from Vanessa Moll asking, what about the ASEAN Intergovernmental Commission on Human Rights? Could it take a similar role as the European Court of Human Rights?
I can take this one first. I think many people here have a specific view about ASEAN, especially because of its consensus-based decision-making model. Everyone needs to agree in order for ASEAN to do something, and that can make things really inefficient and a lot of inaction there. But when it comes to ICHR, the ASEAN Intergovernmental Commission on Human Rights, there's actually a complaint mechanism under ICHR established, I think, in either 2017 or 2018. But in my opinion, the effectiveness of this mechanism is still not there. That is to say, when you make a complaint to ICHR, the Asian Intergovernmental Commission on Human Rights, they basically send that complaint to the country representative. So if I were to send something to ICHR, then ICHR would then send it to Thailand's representative that has been appointed by the Thai government, about whom I'm complaining. So as you can see there, when it comes to ICHR, I think it's a body that we need to engage with, but I think we also need to be clear-minded about the nature of the institution that we are engaging with.
Thank you so much. I just want to let folks know we'll have about 5 more minutes for questions. So if you have a question, it is a good time to put it in the Q&A box. Another question from Sudatip Kamratana asking that, is there, and I'm just going to expand it to say, is there any effect on Freedom Bridge or on Thai Lawyers for Human Rights in terms of funding from the US after Trump came into power? And then if so, what are your expectations and plans in the future under this constraint? And I would actually I realize this is all speculative, at this point because it's still, it's still unfolding. But for all three of you, what kinds of concerns and challenges do you think may be coming in during this 4-year period?
How much do you want to hear about this? That was not a good question. So that's a whole other webinar.
I think Kunit can explain the
I think I
impact
can
on
answer
freedom.
this one. So, actually, the effect on funding from the Trump administration is already clear in Thailand. That everything will be freeze and cut. So in the beginning, we will promise a certain amount of budget that will go into support of our project and political prisoners. It was approved, but it was frozen. Now it's not there. It's not gonna happen. So the expectation and attitude in general is that it's just we are treating it as it's not there. We are not the only organization in Thailand affected. Almost majority of CSO organization in Thailand are affected. Some are heavily affected. They have to be closed for within a month or two. So what we are trying to make sure is that we can sustain our support to political prisoners and their families, especially due to the fact that we still will have more and more cases. Before Freedom Bridge, there were a wave of many people going into exile. This is, we cannot say that this is due to the fact that there were no support available for them if they were to go into prison, because it was not there, we don't know. But it's just now we want to make sure that the support is there for people who are inside and for people who are about to face this, that they know that something is out there for them and their family, and whatever decision they will make is up to them, but the support is being sustained there. This is also promising to many activists who know that they might be facing this situation soon. Many activists, some organizations' budget is already dried out. So we might see less campaign, less advocacy effort and all that. So our plan is just to make sure that we will gather all the type of resources, do more fundraising to sustain this support. If you are interested in Freedom Bridge work or have any support besides, donation and all that, or you want to link us to people and all that, you can email me directly, and we are open for collaboration.
Thank you so much. And I'll just flag again that the links for both Freedom Bridge and Engage Thailand are in the chat. So for people who are concerned, a good thing to do is to donate. I think a great question on which to be our last question is that from Sarah Bishop asking, in Frank's presentation, he spoke about generations of human rights lawyers and emphasized some of the advantages that lawyers of the 4th generation, Arnon's generation, have. Something I wonder listening to the presentations is, what is the effect of current repression likely to be on this and later generations? How might it undermine some of the gains that have been made? And I think asking this question of what does Arnon's imprisonment mean for those who are currently approaching or undertaking a career in law?
Well, I'd be happy to answer that. Sarah Bishop knows a lot about Thailand's jurisprudence and its courts. Sorry, I'm having trouble with this morning. So far, it seems to me that this community of lawyers that's been created over time, and it's taken shape in a number of NGOs, Thailand Lawyers for Human Rights is a foundation now, right? Seems to be holding up, but it could collapse at any time. I mean, you can see that the Constitutional Court is facile with its reasoning about the Constitution, and if it suddenly shifted ground to just cut into more of what that organization does, although Akarachai, what you say, it doesn't suggest that the court is about to do that. They've been responding to situation-specific cases. Well, actually a whole generic group of cases too, but they haven't interfered directly with other legal work, even though it's clear the police have their own ways of circumventing what you want to do. For the future, I mean, we're all awaiting the next election and what happens when certain restrictions in the current constitution expire or pass a limit. And it's anybody's guess. I'm really no longer in a good position. I mean, my intense interviewing stopped a few years ago, so I'm not as up to date on the current situation as some who were there and continuing to work on the ground. And the other panelists here are in a better position than I am to predict the future or make some kind of projection. But I don't see it as an issue that's been resolved yet at all. And I have great hope, given the resurgence of Future Forward and in many different guises, that's going to continue and it will keep pushing things. And I don't know that the old regime has the capacity, has the levers still to maintain legitimacy and really clamp down more than it has. But I put that out there for further discussion. Thanks for the question, though.
Kunit or Kun Akarachai, would you like to add any final additions?
I think just one small note. I think obviously we are facing quite a lot of obstacles, but I think we have come quite a long way. And I say this in almost all talks I've been in. If you asked me 5 years or 6 years ago, before the 2020 movement, whether I would be here speaking about this issue, my answer would be a definite no. But here I am speaking about this issue. And I think there's a huge cultural shift in the country. For those who have come to Thailand, if you have been to the cinema, you know that we played a royal anthem and everyone would stand up before the movie plays. A lot of people, the majority of people no longer stand up. And to me, that's unfathomable. I've grown up in Thailand for more than 20 years. I always stand up until no one does and until I don't. So we have come a long way. There's a lot to celebrate, but I think that the fight remains ongoing. We need to continue to fight.
Thank you so much, Kunit.
I guess I'm just, if anybody is interested in freedom-based work, you can reach out to me through my email and we can discuss more. And, democracy is a struggle to earn and it's a struggle to keep, as we can see. Democracy in the US affects the rest of the world. Democracy in Thailand affects the rest of the region. So, if you have any interest, way to work together, way to collaborate, just reach out to me. Thank you.
Thank you so much. And I wish we were in an actual room and so everybody could clap and we could collectively call out for the release of all political prisoners. Sometimes screens are really unsatisfying. But I just want to say thank you so much for sharing your insights, your accounts of what's taking place, and for all of the important work that you are doing. And thanks to all of the participants for your great questions. And may we one day, I'm not going to say next time, but may we one day be gathering to celebrate the release of Arnon Nampa and all political prisoners and the return of democracy in Thailand and to its flourishing around the world. Thank you so much.
Thank you so much. Thank you so much. ขอบคุณครับอาจารย์ Tyrell. Thank you everyone. Have a good evening, afternoon, morning.
Have a good day and have a good evening. Bye.